guys, it's Kathy. I hope you're doing well. Today we're going to start off with McBurney. No one does court like McBurney. Just doesn't. The guy came in front of McBurney and it didn't go how he expected, which normally doesn't in front of McBurney. Then we're going to go to Texas for an interesting case. And maybe I should have skipped, but you'll see why I didn't. And we're finally going to end, where are we going to end? I honestly don't remember Florida for Josh. So if you're new to this channel, we deal with the OJ trial too. And it's always exciting when they get sanctions. So for Josh, because he's in pain and he's not allowed to laugh, we're going to do a good old-fashioned sanctions hearing for a lawyer. But first, McBurney.
Angry with folks, then we may be back together and I'll be disappointed and unimpressed, and we'll see how that plays out. Okay?
Yeah, worry about it. Yeah.
All right. Well, we'll see. Ms. Smith, anything else from the state in Mr. Jones's case?
Yes, I just wanted to clarify. You said that 1 and 2 will run consecutive to 3, but did you mean 1 and 2 will run consecutive to count 4?
I did. Thank you for clarifying that. So it's clear, because Ms. Nelson needs to get this down, and I wobbled by saying 3 at first. It's 7 months to serve on count 4, followed by 12 months suspended for counts 1 and 2. So count 1 is consecutive to count 4. Count 2 is concurrent with count 1. They're both 12 months, and that's suspended. So the overall sentence is 19 months with the first 7 to serve and the remaining 12 suspended. We don't usually talk in months, we talk in years, but you've got misdemeanors. Did that clear it up, Ms. Smith?
Yes.
Thank you. Ms. Wood, anything else?
No, Judge, thank you.
All right, Mr. Jones, go home and rest.
I don't know why he's going home, because he just got 9 months.
Well, this was fast. Who's this?
This was the next position, yes, what was it?
Kev Andrews.
Andrews, sir. Position number.
Mr. Andrews, number 4. Got it.
Judge, I don't know his name. Why are you asking me my client's name?
Thank you.
One second, right?
That's fine. Ms. Rios, are you good to go, or do you need more time?
I'm good to go on him. With Marcus Smith, there's a hiccup that we didn't know about it. There's 2 other cases that we want to get resolved with him. One was not on the calendar, so he total has 3 open cases and 1 unindicted case.
Okay, well, we'll come back to Mr. Smith. We've got Mr. Andrews standing right there, and let's work through his situation. So we're on the record. This is 25 SC 000-719, State versus Andrews. Good morning, Mr. Andrews.
Hey, how you doing, sir?
I'm okay. How are you doing?
I'm doing all right.
Good. Mr. Andrews is represented by Ms. Rios here in court, and Ms. Smith is representing the state. And Mr. Andrews, Ms. Rios tells me you are ready to enter a plea in your case. Is that correct?
Yes, sir.
We're going to do that. Ms. Smith will put you under oath, ask you a bunch of questions. You need to let me know if at any point during our conversation you've got questions, because you're confused by something or you just want to know more about it. Will you do that?
Yes, sir.
Okay, Ms. Smith.
Mr. Andrews, please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay, with the Lord in hand. Please state your true, correct, and legal name for the court.
Calvin DeWarren Andrews.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
And is there any medication you normally take that you haven't been given this morning?
Yes, ma'am.
What do you take medication for, Mr. Andrews?
I have nerve damage. I have got shot in my right leg.
Okay, and do you get medicine at the jail for the nerve damage?
Yes, I get medicine at the jail.
Is it a painkiller, or what is the medicine supposed to do?
The medicine at the jail is It's for my nerve, but for my pain, they don't have that medicine at the jail.
Oh, so you've not been getting the medicine?
I've been getting the medicine. I've been getting one on, but ain't been getting the second of.
Okay, but all the medicine you take when you're taking it is for the nerve damage in your leg?
Yes,
Okay. The medicine that you are getting, sounds like you're getting one of two. The medicine that you are getting, when you take that, does that make you drowsy or sleepy?
it helped me sleep.
It helps you sleep. Okay. The medicine that you're not taking, because you're not getting it, does that make it hard for you to understand what we're doing here today?
No, sir.
Okay. And the medicine that helps you sleep, when do you take that?
I take it once in the morning and once at night.
Okay. Did you get it this morning?
Yes, sir.
Okay. Has it made you feel sleepy?
No, sir.
No. Okay. All right. Ms. Smith.
Mr. Andrews, how old are you and how far have you gone to school?
I'm 45, 12th grade.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, ma'am.
Have you had enough time to speak with your attorney about all of the facts and circumstances known to you regarding the charges in this indictment?
Yes, ma'am.
Do you need more time to discuss your case with your attorney?
No, ma'am.
And are you satisfied with her services?
Yes, ma'am.
Counsel, are you satisfied your client has a full understanding of this proceeding?
Yes.
Also, do you waive the formal reading of the indictment and any and all defects in the indictment for the purposes of this plea?
Yes.
Mr. Andrews, do you remember being arrested for these charges?
Yes, ma'am.
The state is unaware of any outstanding warrants related to these charges. Are you or your attorney aware of any outstanding warrants?
No.
No, ma'am.
Do you understand that this is a non-negotiated or blind plea and that the state will recommend a sentence to the court?
Yes, ma'am.
And are you aware that the state's recommendation is 6 years to serve one balance prorated?
Yes, ma'am.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, ma'am.
Do you understand that this is a guilty plea, which is permanently recorded on your criminal history?
Yes, ma'am.
Do you understand that if you're charged with a crime in the future, that this plea may be used to enhance that sentence?
Yes, ma'am.
Are you currently on probation?
Yes, ma'am.
Do you understand that since you're currently on probation, your probation may be revoked based on you entering this guilty plea today?
Yes, ma'am.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be following a
Even
conviction
without
from a
violating
trial?
hours.
We'll talk about
Yes, ma'am.
For example, your guilty plea may affect your right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, or the ability to obtain employment.
Yes, ma'am.
Do you understand that by pleading guilty to a felony, you cannot use, receive, possess, transport, or own a firearm? And that if you did, you could be charged with another felony offense.
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, ma'am.
Do you also understand that by pleading guilty, you are giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to see and hear the witnesses called to testify against you, the right to the assistance of counsel, either hired by you or court appointed if you cannot afford an attorney, the right to the presumption of innocence, which means that the state must prove beyond a reasonable doubt that you're guilty of these charges, the right to testify on your own behalf or remain silent, the right to present other evidence of your wrong and call your own witnesses, and the right to appeal if convicted of these charges after a trial.
Yes, ma'am.
Counsel, are you satisfied your client understands these rights appear to be waived by entering this guilty plea?
that. Yes.
Mr. Andrews, has anyone forced, threatened, or promised you anything for you to enter into this guilty plea here today?
No, ma'am.
As to indictment number 25 SC 0000719, how do you plead to count 1, possession of crack cocaine, and count 2, possession and use of drug-related objects?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
Do you understand that you do not have a right to appeal directly from your guilty plea? But if you believe that there is some error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal.
Yes, ma'am.
Do you also understand that that has to be done within 30 days from today?
Yes, ma'am.
Do you understand that you have only 4 years from today for a felony charge and 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, ma'am.
Thank you, Mr. Andrews. Your Honor, if this case were to proceed with trial, the state would show that on February 7th, 2024, officers with the City of Atlanta Police Department were patrolling the area of Winchester Street, that's in Fulton County, in a marked police vehicle when Atlanta Police Department investigator requested assistance referencing a man sleeping inside of a car. That same car was later announced on the radio that the car was now mobile and driving down Winchester Street. At this point, officers observed the person in the car who they identified as a defendant as not having a seatbelt on or having a seatbelt behind him. Because of this, the officers conducted a traffic stop. Once the officer got to the car, they smelled a strong odor of marijuana coming from the vehicle. Because of this, they asked the defendant, Mr. Andrews, to step outside of the car. When they searched the car, they did find suspected crack cocaine that was confirmed by the GBI lab as 1.089 grams of crack cocaine. At this point, the defendant was placed under arrest and charged with the crimes that are before us today. And those are the facts of the case. Regarding the recommendation from the state, for count one, the state is requesting 6 years to serve 1 balance probated, and for count two, 12 months probation to run concurrent with count 1. Regarding the special conditions, the state is asking or recommending for the defendant to complete a drug and alcohol evaluation with treatment if necessary, for there to be a Fourth Amendment waiver, and also for the defendant to not have any drugs that are not prescribed to him. Regarding this recommendation, Your Honor, the state is asking for that 1 year to serve based on the criminal history of Mr. Andrews, and also for, we believe that there's a high likelihood of Mr. Andrews reoffending, so that's why we're asking for the 1 year in custody. That's all from the state, Your Honor.
All right, thank you. I overheard you chatting with your colleague and with Ms. Rios about statutory ranges. This is not 1 to 3 because of the quantity of, so if it's more than a gram, which this was just barely, then it's 1 to 8?
Yes.
Okay, got it. Thank you. Mr. York, can you please share criminal history information on Mr. Andrews? I know he's got at least 5 felonies. I've looked at the recidivist notice that was filed, and that shows a pretty recent one from 24 and then some older ones. But I'm interested in, number 1, the total number of cycles, and then 2, if you actually count more than 5 felonies.
And I have 21 cycles, and correct, I have probably the same 5 that you had. That's what I'm showing.
Great. Well, then I've got that info. So I think I got everything from that paperwork. Anything else of note from your review?
No, sir.
Okay, thank you.
Yes, sir.
Ms. Rios.
Yes, Your Honor. Mr. Andrews is 45 years old. He's from Atlanta. He has 4 children, 2 of which live with him, ages 10 and 15. Before he got arrested, he was working for Ayers grocery store and restaurant, working some hours. He couldn't work a lot because of his injury, and he wants to go back, but his injury is the gunshot wound has made it difficult to be able to work. He's trying to get disability because of his leg injury. I'm asking for, on count 1, 5 years probation, and count 2, 12 months probation to run concurrent.
Ma'am, axing is definitely a felony.
It wasn't a lot of cocaine from my understanding. And I understand that he had a case in 24, but before that did not have repetitive arrest. And because of that, and this is a nonviolent charge, that's why I'm asking for him to have probation and to waive the fees, since he's trying to get disability and he's going to have some trouble paying for probation fees when he first gets out.
Did you explore with Mr. Andrews, the possibility of doing drug court?
We talked about it. We didn't, after discussing it, we've discussed, it wasn't a good fit for him to do drug court.
And tell me, he can or you can, what about it is not a good fit? There's not a need for it, or it cramps his lifestyle, or?
I don't believe it's a need for it.
Okay. Your sense is that, well, let me ask you, Mr. Andrews. You have 1, 2, 3, 4 drug convictions already. 2 of them are real old, 1 is kind of old, and 1 is not old at all. And now we've got this case. So you are around drugs a lot, and it seems to always be cocaine. Is it your view that cocaine is a business for you? You sell it because it's a way to make money, it's a hustle? Or are you around cocaine because you need it, but you may sell some to support you being able to get some?
At the moment, I was, you know what I'm saying, I was selling, trying to, but that was back in my past. Like, I'm like really through doing it. Like,
July.
I was never used.
Back in his
I'm
past.
not used.
Okay. And I ask not because things will get worse for you. I just want to make sure we're providing support so you can make a change. You're 45 now. You're not 21.
That's why I say I don't got too old to be.
You have gotten too old. But I work with people who are your age, but because of the addiction, they can't get out of that line of work because the way they get their supply is by buying a bunch, selling most of it, and that gives them the money to go buy more so they can have some. I'm not saying that's you. I don't know you. But if you are in the drug business because you are needing drugs for yourself, then you ought to get help because then it'll be easier to get out of it.
No, I don't need.
That's not your deal.
No.
Okay, understood. I'm gonna take you at your word. All right, what I'm gonna do in light of, let me check one other thing. There was an arrest July last year for drugs. And Mr. Andrews was in jail for 3 days. That was it. And then he got out. Any idea what happened with that charge? Is that a PI case now, Ms. Smith, or it may have been something that went through state court? It was definitely a misdemeanor for the marijuana, but then it was possession of a Schedule II controlled substance, which could be cocaine. And that was a felony charge. He posted bond for it and moved on.
On my end, it just looks like it's an open case, so it's not a PI case, it's, I'll look at to see if I can get the case number, but, it seems to just be an open case.
Okay, I guess I can click on the booking number too and see what. There's a PI number, so it's 25 PI 006002. Okay. Mr. Andrews, I find that there is a factual basis for your plea, meaning back in February of 24, you had what you had in your car. And I also find that your plea is knowing and voluntary. Knowing means you've understood what we talked about. Is that fair?
Yes, sir.
No questions about anything? Okay. And that was you're shaking your head no?
Yeah, no, sir.
Okay. And voluntary means that no one is coercing you or making you enter this plea, but you've decided it's time to move forward with this. Is that correct?
Yes, sir.
Okay. Then I'll accept the plea. Ms. Rios, can someone in my office sign the indictment for you?
Yes, Your Honor.
Ms. Smith, can we sign for you?
Yes, Judge.
And Mr. Andrews, can we sign your name to the indictment indicating your guilty plea?
Yes, sir.
All right. Ms. Smith, are you withdrawing the state's recidivist notice?
We are withdrawing under A, but not C.
Okay. Were you aware of that, Ms. Rios?
No. Not aware of that.
Okay. It's already a non-negotiated plea. So
Oof. That changes everything.
Mr. Andrews has the ability to withdraw his plea. But I guess you guys should make sure you touch base. The state is being much more consistent in filing recidivist notice now. And so when I see it in the docket, of course, I need to ask, because if it's not spoken that it's withdrawn, then it's sitting out there.
Judge McBurney, I know you didn't try to intentionally lie to every single person right there, but the state is not, in fact, being any more consistent with filing recidivists or anything else in Georgia. Nothing the state does is consistent. You guys are terrible is not even the right word. You have people sitting in jail for 900 days without being indicted. So do not say that the state is getting better at doing anything, because they flat out are not. And all of us are offended to our core because we trust you when you speak, Judge. And then you say words like that.
So, Mr. Andrews, where we are now is if I sentence you to any time in custody beyond what you've already served, and you've done just under 6 months. If you
See? See? He had a gram on him. He's been in there for 6 months. He's now getting in front of a judge to plea or something. 6 months.
combine the 2 times you've been in, that you are not eligible for parole. So I'm just gonna make it up. If I said 7 months, then you do every day up to 210 days. And you've done about 160 right now. So you do 50 more days. You wouldn't get out after like 2 for 1 or something like that. You understand that?
Yes, sir.
Okay. And that's just a product of your criminal history. The state filed the right notice for that. Ms. Simpson, is Mr. Andrews on probation right now? And do we need to, assuming Ms. Rios is comfortable going forward with it, handle a revocation?
He is on probation, Judge, but this case does not put him in violation due to it actually happened about the same time.
Oh, it's the 23 SC, but he didn't plead to that until March, and this happened a month before.
Correct, Judge.
Whew. Saved by a delayed plea. Okay.
Exactly.
All right. And Mr. Andrews, I wasn't going to change what I'm going to do here. I just would want to match up the revocation if there was going to be one. But this plea and conviction is not a basis for your other probation to be revoked. Ms. Simpson, how much time is left on that other case?
Judge, he has 3 years, 20 days remaining.
Okay. All right. Got it. And no to drug court. All right. Mr. Andrews, I am going to sentence you as follows in light of all the moving parts that we've got here. You had been arrested for and indicted for, but you hadn't yet pled to the case you're on probation for when this happened. So already things in the mix, and you got caught with drugs. While these charges were open, you got arrested again, and it's an open case. It has not been indicted yet for having drugs. You're telling me that's a line of work for you as opposed to addiction-based, and I'm gonna trust you on that. But I'm not seeing that you have quite yet disentangled yourself from those kinds of things. And I really want to encourage you to do that, given that you've got a bunch of kids and you're getting to an age where you're just going to be a little less resilient when you and the police have to spend time together. So I'm going to sentence you on count 1 to 5 years to serve 1 year with the balance on probation. You'll get credit for all the time that you've been in. Your sentence for count 2, which is a misdemeanor, is 12 months to serve. It'll run concurrently. That means at the same time as your sentence on count 1. Special condition of your probation would be that you submit to a drug and alcohol abuse evaluation. That's just you meeting with I don't know if it's a nurse or a subject matter expert, and you'll talk with them and they'll be able to get much more detail about what you drink, what you use, and this and that. And if they conclude that you need treatment, then whatever that treatment is part of your probation. But if it is, as you say, hey man, I smoke a blunt every once in a while, and you didn't say that, I'm making that up, or you drink some beer, you don't need treatment for that. You're not going to get treatment for that. You will have a Fourth Amendment waiver, which means that the probation folks can search you or your car if they have a reason to do so. I'm going to waive your probation supervision fees for the first 6 months after you're back on probation, so you can see if you qualify for disability, and so it's conditional. If you qualify for disability and begin getting disability benefits because of what happened to your leg, then you will not need to pay probation supervision fees. It doesn't make sense to take government dollars to pay the government. But if for whatever reason you don't qualify for disability, then after 6 months, you'll need to be paying those supervision fees. Okay? So
I use credit cards to pay credit cards, so I think it works out.
that is my sentence that I think is appropriate given all the things I've learned about you, your situation, your criminal history, etc. That's different from what Ms. Rios asked for. And we're early enough in this process that I'm gonna ask you to talk with Ms. Rios, because you can withdraw your plea, doesn't get you in any trouble. It's not gonna get you out of jail, but we could then say, all right, Mr. Andrews said no thank you to this, and then we'll get you in line to have a trial some number of months down the road. But I want to give you a chance to talk to Ms. Rios about it, because she advocated for one thing and I did a different thing. Okay?
Yes, sir.
Any questions about what I've said?
No, sir.
Okay, you and Ms. Rios should talk, and then she's going to let me know what the plan is. Okay?
Yes, sir.
Thanks.
I left this part in, you'll see why. Oh, we're not done with that
Everything all
customer
right?
yet, but we will have a next
And we're out
customer.
of TP in there? Come on, sheriff's team. Sheesh. Full service.
That's a
You pull
shitty
rank on him?
situation, huh?
Like, you get that. Yesterday, when they were making a big deal out of what was back there in the car, I thought that little girl had gotten sick or gone to the bathroom. I don't know if you were here, joke, the guy brought his little girl to court, and then when it was over, everyone was huddled around the bench there, and they were mopping and this and that, and it's cookie crumbs. It was nice they were cleaning it up, but, all right, let's get back on the record with Mr. Andrews. Mr. Andrews, I wanted to do some math with you, and then it sounds like you're thinking about going to trial, which is your right.
I just need one more chance, you know. I got a family out there. I'm losing everything just sitting in here. I ain't no bad person. I ain't got no violent charges or nothing on my record, and but
I don't disagree. No one's saying you're a bad person, and you are not someone going out there gunning and running and beating people up. You do keep getting arrested
For selling drugs. Selling.
with drugs.
But that's what excuse me for cutting you
It's
off.
okay.
But that's what 2 years ago. I'm trying to
July.
better myself. I ain't been getting in trouble for the last 2 years. I got probation. I took probation with this case already in hand.
Yep.
You see what I'm saying?
I do, but then I bumped into you getting arrested in July.
That's because
So I don't want you to talk about the facts of that case. Or just I do. It's important that you and I talk. But if you say, "Hey, that was my brother's drug," I'm making it up. But you got two prosecutors right here who are So don't talk about that, other than I'm observing that you saying I'm all done and that was all a long time ago. And yet here you were getting arrested, and you were at least around drugs, because you and drugs and arrest. And I hear you that you want a second chance. One response to that would be, gosh, you already have 5 felonies, so you've had 2, 3, 4, 5 chances. Those
I did good every time. Like I didn't.
well, when you say you did good every time,
I have never violated on Judge.
well, the only reason why this conviction, if you were to plead, or if you go to trial and you're found guilty, I don't know what the defense is in your case, the drugs are in your car, but if you are found guilty in this case, the only reason why that's not a violation of your probation is that you happen to have this cocaine a month before you pled guilty in the previous arrest for cocaine you had. But I believe you, and I want to circle back to the first thing you said. None of this is about Mr. Andrews as a scary guy who is eating babies or killing women. That's not the situation. But there are consequences over time for getting busted again and again and again. You heard what Mr. York said, 21 cycles, 5 felony convictions, and it's not productive for a court to say each time, well, you know what, let's just try again. At some point, it is, there needs to be I'm gonna shake Mr. Andrews a little bit so he gets it that there isn't gonna be another time.
I need one more chance.
Okay, well, I'm hearing the words. Let me map out where we are. You're at 160 days right now towards the 360. You will be on a trial calendar that gets you back in court, not the actual trial, the call of the calendar at the end of April. So add another 60, you're at 220. Maybe you get called out to trial. On that trial calendar are murder cases where people have been in jail a whole lot longer than you. So I don't know that we necessarily get to your case, but we probably get to it a couple trial calendars after that. And then you're sort of at 300 days, and your sentence here is 360 days if you go forward with it. And I'm not nudging you one way or the other. I just want to make sure you make an informed decision, because if you say no, thank you, that's great. I will see you actually 2 more times. At the end of March is your final plea date. That's the last day you could enter a plea if the state gives you a different offer or whatnot, and still have the ability to withdraw. But after that date, then I'd see you at the end of April for your trial. And that's where we are. So I just want to make sure you understood all the moving parts. But Ms. Rios tells me that understandably, you're not excited about the sentence that I imposed, and you would rather go to trial. Is that correct?
Yes, sir.
Okay, then you're withdrawing your plea. I will not fill out the sentence sheet, and I will see you on March 31st. That is your final plea date. We'll talk again. Maybe the state will have a different offer, or they'll do something with that recidivist notice. But you need to understand that the recommendation they made today, theirs was 6 serve 1. I went a little below that with the 5 serve 1. That's not necessarily what they have to recommend on March 31st. It could be a bigger number, it could be a better number. You understand you don't control that? You understand you don't control what the state offers?
I know.
You know, you've been through this before. Okay. I will see you on March 31st, okay?
21
Ms. Rios.
times.
What about the FTA? FTA can't be lived?
That's something that Ms. Rios can look into and talk to us about later. Today you were here for a plea, and that's what everyone prepared for. And I get why you're saying no thanks. It wasn't what you were interested in. So we'll get you back here, and maybe on the 31st we can talk about the FTA, okay?
There are worse things than loving food. Just saying. There are worse things. Okay. All right, guys. This next one is not screaming chaos. It's court. It's lawyers. Okay? This is a court channel. So sometimes we do things that have lawyers that talk. This is what we're about to see. Hold on, I'm going to show you 2 things. First thing. Anybody recognize that? Anybody recognize what you're seeing here? Your children and grandchildren would instantly know. And I'm just going to say, no, it's not Minecraft. It's not Minecraft. Let's see if this one will help. Boom. Oh, it's so tiny. It's a video game. Yes, Linus, yes. Hugely popular video game, Roblox. Roblox. Been around for many years. Millions and millions and millions and millions of users worldwide, right? Monica, I just got to jump in here. If you don't live in the United States and you eat Hershey's chocolate, it tastes disgusting to you. It is nasty. I don't understand it. I don't understand why. From what I heard, when I tried to figure out why everybody in the world hates Hershey, is so like peanut butter cups. They are beyond delicious. They just are. They are crack cocaine that you can buy right down at the gas station. But the peanut butter part in Hershey's chocolate is fine. It's the chocolate themselves. The Hershey's chocolate bar is like one of the lowest selling pieces of candy because the chocolate is cheap chocolate. They just use cheap chocolate to make Hershey's chocolate. But the things they do with that chocolate, the candies that they make with that chocolate, they're just delicious. But the chocolate itself, if we lived worldwide, we would not like Hershey's chocolate. I love Hershey's chocolate. I love it. But I live in Pennsylvania and you can practically smell Hershey from my front door. You can't, but it's close enough. It's like 35-40 minutes away from me. I know, because that's where I go to the casinos. They just use cheap cocoa. All right. This next one is Roblox versus Texas. Not a full-blown trial or anything. We're just going to watch a tiny clip of lawyers duking it out over venue for Roblox, which I thought was interesting. If you're not into lawyers, then maybe go make a sandwich or something for a few minutes, because we're going to end with the sanctions hearing. But first I need to find our clip. Now I want chocolate. Now I just want Hershey's chocolate.
Okay, it's back on. I didn't get the message this time. Okay, we are now going to go on the record in King County, cause 2025-707, the state of Texas versus Roblox Corporation. We're here today on the defendant's opposed motion for leave from court for hearing, a motion to transfer venue.
So for the first few minutes, it's just lawyer talk. And then they start arguing a bit. So, but you need the first few minutes or you won't understand why they're arguing.
And the plaintiff's cross-action response to that. So plaintiff's opposition to defendant's motion for expedited hearing, a motion to transfer venue, and cross motion for extension of venue hearing deadlines. Before we went on the record, we were looking for a Pro Hop Vice application filed on behalf of, see, Mark Pinkert.
Mark
and-
Pinkert, yep.
Yeah, we were able to find that the court had signed that back in December, and the clerk is gonna go ahead and forward a copy of that file marked. And I believe Mr. Burbach wanted to go on the record and, about that. Go ahead, Mr. Burbach.
Yeah, thank you very much, Your Honor. We just absurd our objection. What we learned is that there were motions pro hac vice filed before we even made an appearance in this case, and they were granted before we made an appearance. However, those motions were submitted by a non-resident Texas attorney, and under Rule 19 of the Texas Supreme Court Rules governing admission, that's improper. Now, we do have here, as I understand it, the various lawyers representing the state. Mr. Hernandez, Ms. Fogel are resident Texas lawyers with the AG's office in Austin. And I believe Mr. Holt is a licensed Texas lawyer, even though he lives in Phoenix. I understand every other lawyer they've gotten to this filing is from a different state outside of Texas, but we wanted to assert those objections on the record.
Okay. All righty, let's go ahead and proceed with the defendant's motion for leave.
Thank you very much, Your Honor. Again, Ed Burbach representing Roblox. And the reason we're here is it's undisputed that on December the 6th, Roblox filed timely its motion to transfer venue. And the court has set a hearing on January 29th at 10 a.m. on that motion to transfer venue, which has to be set 45 days out under Rule Civil Procedure 87. On December the 30th, the plaintiff state was required to file a response or affidavits in response to that motion to transfer venue. It failed to do so. We're now sitting here some 15 days past that deadline. So the state chose not to file a response to our motion to transfer venue. So obviously our motion is ripe for determination. The motion you have before you is our motion for expedited hearing under Rule 87-1. And the reason for that is, and I should say that before you, as the court has indicated, that the state has not filed a response to our motion to transfer venue. They've only filed an opposition for our motion for expedited hearing. And they have asked you to delay the venue hearing that's already set on January 29th to February 15th. Or alternatively, they seek a further extension for the response deadline to January the 16th. They claim in support of that motion that they wanted to seek what they refer to as limited discovery under Rules Civil Procedure 258. However, 258 is only reserved for motions to transfer venue under 257, where the defendant is alleged can't get an impartial trial, which we have not raised here. However, having said that, the plaintiff did on December the 23rd, serve us with 17 requests for admission, 3 interrogatories, and 1 request for reduction. Even though those responses were not due until long after this hearing, we went ahead and responded to do them anyways. And we also filed on January 11th, 2 days ago, our reply. What's important for the court to know is, why have we asked for this relief? The bottom line is it's to alleviate the time crunch, which will unnecessarily be placed on the court with proper venue to rule on our upcoming motion to dismiss the lawsuit. What's interesting is the 91A motion to dismiss must be granted or denied within 45 days after the motion is filed. What's interesting is...
Nothing is interesting so far, but you know, the bigger picture of this case is pretty interesting. Louisiana, Kentucky, Other states are also suing Roblox, plus parents of some children that were, involved in this are also suing Roblox. So Roblox is a game where kids get on. Okay, I get on Roblox often, and I'm not a kid, but people get on Roblox. It's basically children, and they play these little games. They sort of look like Legos. All the world sort of looks like Legos, but they're not Legos. And you can play all kinds of games, a huge variety of games. So the kids get on, and there's it. I know when I play, it doesn't let me swear. It just doesn't let me swear. It will not let me swear. But apparently, just because you can't swear doesn't mean that they stopped other types of conversations to happen. So the kids are all grouped in this game, and the predators would come on, and they would have these conversations with children that were inappropriate and led to in life meetings with these predators. The children met up with these people. So they're getting sued by a whole bunch of people for not protecting the children. That's what's happening. Although, it's horrible because the game. So to put it in perspective, millions and millions and millions and millions of children play this game, and it's a tiny, tiny percent of children that these predators got to and ruined it for everybody.
The plaintiff opposes our motion to transfer venue in an expedited hearing, but their proposal would leave the court with proper venue. And obviously, we believe the court with proper venue is Travis County. But whatever court has proper venue, Your Honor, would leave them with only 18 days to receive transfer of the case, its materials, schedule a hearing, and before a final ruling has to be made on that motion to dismiss by March the 5. And I'll explain this to you, Your Honor. So on January 19th, that is the last day under the rules that we can file our motion to dismiss. And obviously, to give the court more time, whether this court or whatever court more time, we will be filing that on January the 19th. And that's under Rule of Civil Procedure 91A 3A, which requires that motion to be filed within 60 days after the first pleading containing the challenge cause of action. Obviously, in this case, it's the original petition. The earliest a hearing that can be had on that motion to dismiss is February the 9th, because the motion must be filed at least 21 days before the hearing is heard. And the latest that a court with proper venue can rule is March the 5th, and that's under Rule of Civil Procedure 91A3C, which requires the court to grant or deny the motion within 45 days after the motion is filed. So, Your Honor, the court with proper venue, whoever it is, will have insufficient time because under Rule of Civil Procedure 89, the file has to be transferred to the proper court following the ruling on a motion to transfer venue. The clerk has to put together a transcript of the orders, certifying those and send it with the original papers. The proper venue court must then assign the case to the appropriate district court and or judge. And Judge, you may know in Travis County, we have the centralized docket, so there'll be an assignment to somebody if the court grants the motion to transfer venue. Obviously, this court, if the court decides that this is a corporate proper venue, which we heavily dispute, the court in King County would have to do all these things. You have to have 14 days notice of the hearing on the motion to dismiss under Rule 91A6. A response has to be filed no later than 7 days before the date of the hearing under Rule 91A4, and there's an opportunity for a reply in the hearing. our position is the state has already chosen not to file a response to the motion to transfer venue, which again was due on December the 30th, and they chose not to respond. And we would argue, Judge, that is really unusual for a plaintiff to claim they need more time to prove up the venue, which under Rule 13 they asserted they had in King County. You would think that if King County was truly a proper venue, which we deny, it would be quite easy for them to set forth the venue facts which they claimed they had when they filed this lawsuit last year. Um,
So, so they do that in Texas a lot. King County is much smaller than, filing it in other bigger counties, which means, the judges will take civil cases like this in King County. So that's why the AG's office filed it in King County. Roblox is saying, no, King County, no.
If you'll recall, Your Honor, within their pleading, they almost, despite their pleading, I think was about 93 pages long, the only reference whatsoever to King County is an allegation in their venue paragraph where they claim the cause of action arose in King County, uh, and that transactions and events occurring in King County are the basis of their claims. But when you read the petition, Your Honor, it just talks globally about Texas. It doesn't say anything about King County whatsoever. And when the court, if the court hasn't done this yet, look at our motion to transfer venue, which we filed several weeks ago, uh, we were unable to find any user of Roblox whatsoever in King County.
Lies. Okay, that's a lie. That's just a lie. I'm sorry, you're lying. There's absolutely no way. There is not one child in Kings County that does not play Roblox. It's a lie. There's no way.
And Your Honor, just for a little background, Roblox, as a reminder, is a computer platform where people can create experiences and go online to do so. Um, what's interesting is when we checked, we literally have no users in King County and never had. And the company's been around since 2006. So it's just a
Bullshit.
very, very odd venue, Your Honor. With all due respect, I'm sure King County is lovely, but it just is very odd that the state is opposing this motion to transfer. And you'll see in our motion to transfer makes it even more odd because, as you see on this call, the state has outsourced this lawsuit to outside law firm from Virginia with counsel from various states, Virginia and Miami and I think Arizona otherwise, and in their own contract with the state. And the court knows that the state has sued my client for attorney's fees. And their very own contract, they set forth that all disputes with regard to attorney's fees would be in Travis County. So the bottom line, Your Honor, is for this particular motion we're here today, we think the motion to transfer venue is already ripe. There is no response that's been filed in front of this court, which was supposed to be filed way back on December the 30th. They chose not to file a response. There's no reason whatsoever for the court not to take up the hearing earlier than January 29th. And again, I would highlight we're doing this because whatever court hears the motion to dismiss is frankly going to need time to review the record, the pleadings, the filings, et cetera. And therefore, that's why we filed the motion for expedited hearing, Your Honor.
Okay, response?
Yes, Your Honor, thank you. Well, there's quite a lot to unpack there. So let me start with Mr. Burback's statement that we say in the venue allegations that all the things just happened in King County with respect to this case. Your Honor, we say King County and throughout the state of Texas. And that's intentional because this is a statewide case, Your Honor. There's no one locus of any transaction that's at the center of this case. Roblox itself doesn't have a principal office in the state. This is about an online platform that reaches throughout the state, that advertises statewide, and that reaches 150 million users throughout the country. So this is about the entire state of Texas, and it's brought on behalf of the state of Texas in its sovereign capacity on behalf of all residents. So venue is clearly proper. We disagree with Mr. Burback that venue is not proper here. The reason that we didn't respond is we immediately filed a motion for an extension because Roblox introduced a factual assertion. And not just any factual assertion, Your Honor. As you said today, they looked back for 20 years and said they found no users whatsoever in King County for the entire history of the company. Their only support for that, Your Honor, the only support behind that is the affidavit of a Roblox paralegal. So we know nothing about this investigation. We found out a little more in their responses to our interrogatories last night. But our view is we can turn around and we can justify venue very easily on the law, on the allegations, on the facts as we know them. But if Roblox is going to make these statements and affidavits, we ought not to forfeit the opportunity to respond to that by taking discovery and getting behind this assertion that they have an in-house paralegal who could speak to the whereabouts of their users, millions and millions of users for 20 years.
So he just said, well, we could have. We can answer that. We just haven't responded, but we can respond easily.
For them to, they thought that factual assertion was significant or worth filing into their motion. We disagree. We don't think it's going to carry the day. But our view, and the reason that very promptly we moved to extend, is that we wanted to have the opportunity to take discovery, and we did serve discovery right after that. So, Your Honor, in terms of expediting, Mr. Burback talked a lot about the proper venue. The proper venue is presumed to be here. Again, the venue law is clear on this. We think it's clear, but at least the presumption is that it's going to be here. So there's no reason for you to rush to get it out, even if you think that it would be improper down the road, because you have jurisdiction to rule on the motion to dismiss. But the presumption is it's going to be here, that you're going to rule on the motion to dismiss, and we think it's going to stay here in the long term. So, and I'm happy to get into the underlying motion, but on the motion to expedite, Your Honor, there's sort of no purpose in rushing that based on Roblox sort of introducing these factual assertions that need to be tested. We ought to have time to look into that, to respond fully. Otherwise, they're going to have these assertions that we haven't had a chance to respond to. So that's our reason for extending. And that's not to say that we can't turn around and establish venue within a few days if we need to. So our view is that it's properly established, and we just want to have a fair opportunity to respond to these very broad assertions that the company has made.
They just want a fair opportunity to respond. The deadline for responding passed, and they did not answer.
Your Honor, if I could respond, the argument of counsel really is a jurisdictional argument. This statewide jurisdiction is interesting, but that's not venue. Venue in Texas, they had the burden to establish a proper venue in Texas. Their responsive deadline was December the 30th. They chose not to file a response. They had the affidavit from Roblox plenty of time to include any kind of arguments in a response. They chose not to, Your Honor. And they did, as you indicated, they did issue some discovery. We could have laid behind the log and not responded yet. We did the opposite, Your Honor. We responded to it, and it still shows no proper venue in King County. And the second thing I would like to highlight, Your Honor, is we moved to transfer venue on two grounds. One, that King County is not a proper venue, which it is not, and they have not met their burden. Secondly, we moved to transfer on convenience. And you'll notice in our motion to transfer venue and it's highlighted in this hearing, Your Honor, that, for example, all of the lawyers representing the defendants within Texas are in Austin, Texas. All the lawyers representing the AG's office with the AG's office are in Austin, Texas. I think there's 7 lawyers in the pleadings, Your Honor, that are literally within 2 blocks of the Travis County Courthouse in Austin, Texas. We are in Austin, we're within a mile of the Travis County Courthouse, but we're all within 361 miles of Guthrie. Also, as we indicated, there are no users of Roblox in King County. But I believe, as you'll see on motion to transfer venue, there's 144,000 in Travis County. So I'm glad counsel indicated that, I think he said we can easily justify venue. I agree with them. If there were proper venue in King County, they would have easily justified it and met their burden. They haven't done it. They've missed their response deadline. We've responded to discovery they claim they needed, even though they claim they were entitled under a rule that has nothing to do with our motion. Remember, they cited the 258 that deals with the 257 transfer for impartial trial, which we did not raise. But nevertheless, we didn't hide behind the log. We responded to the discovery. So bottom line is, I think counsel just admitted that the court can take this up, can take up the motion to transfer venue now. And we would argue that if you choose not to, Your Honor, whatever the proper court is of venue is going to be really squeezed on that motion to dismiss if we wait until the 29th. So we would again encourage the court to take up the venue now. If the court chooses not to, I guess we'll have the hearing on the 29th, but that's what, 16 days from now, but there's no reason to wait. And we do think it will squeeze whatever court, yourself or the court, which we would argue in Travis County, one of the courts, whichever one you decide has proper venue, or if it's convenience, we would argue Travis County is both the proper venue, a proper venue, and convenient. There's no reason to squeeze the court, so they have so little time to consider the motion to dismiss, Your Honor. So we again would ask that you would take up the motion now.
Your Honor, can I respond in a minute?
Mhm.
First, again, Mr. Burback keeps saying we didn't file a response. We cross-moved right away, and we're here now on a hearing on both their motion to expedite and our cross motion to extend the deadlines, which the court has not ruled on yet. Again, he keeps saying 144,000 users in Travis. That is based solely on the say-so of their in-house paralegal and an affidavit. We haven't had a chance to look into that. And Your Honor, Mr. Burback's, all the facts about where the airports are and where the lawyers are located, that's all a sideshow. It's all beside the point. To get a convenience transfer under Texas law, you need to show that you have an economic or personal hardship such that it would be unjust to hear the case in King County. Roblox hasn't even tried to make that showing, Your Honor, and they couldn't. It's a $60 billion company. Certainly, Mr. Burback would prefer to be in Austin, and I understand that, but that's not his prerogative. The plaintiff brings suit in a proper county, which we have, and we can establish that. But again, as I mentioned, we just have not had the opportunity to fully respond to their factual assertions. If they think those factual assertions are necessary to the determination of venue, we want to have a chance to probe them and not let them sit on the record going untested. But Your Honor, again, it's the statewide argument is not a jurisdictional argument. It is a venue argument. Under 1502A4, the plaintiff can bring a lawsuit in any venue in which the plaintiff resides, provided that the defendant is not a natural person, provided the defendant doesn't have principal offices anywhere else in the state. Roblox has admitted that they don't have any offices in Texas. They have some remote employees. And if there's no one single locus of events in another county. And we have not alleged anywhere in our complaint that there's one location in which any transactions or any events took place. Again, this is about online accessibility. It's statewide. And so under the general jurisdictional provision A4, it's clear as a matter of law that the Attorney General on behalf of the state can bring a lawsuit in King County. We also have venue under the Deceptive Trade Practices Act, under the had done business provision. Mr. Burback's brief, we haven't responded to it yet because we want to do so fully, but they talk about having done business as just users. And there's plenty of case law talking about advertising, and we have lots of facts about statewide advertising and marketing. We just learned last night that they sell or that they've had sales for their online currency in King County, so there are transactions. So, Your Honor, it's proper venue.
Excuse me, sir. Excuse me, sir. How could there have been transactions in Kings County? How is that possible? When apparently there's not one Roblox user in all of King County. See? Told you it was lies.
And these arguments about, well, where the lawyers from out of state and the airports and convenience, it is just totally beside the point because they just cannot make the showing that they have an economic hardship. That provision, Your Honor, is about someone who can't put gas in the tank to get to the next county. Otherwise, it's a heavy
Prove
burden
it.
to show that that you're going to take the venue away from the plaintiff who has the prerogative. And so I disagree, and I think as long as Roblox has made those factual assertions, there's no reason that you can't decide that on an orderly track with discovery and a hearing down the road, and then also decide the motion to dismiss. And one final point, Your Honor, Mr. Burback talks about the court being pressed. The venue provision is about giving substantial lead time before trial. And the cases they cite are all summary judgment. We're not even 6 weeks into the case, maybe 2 months, barely. This is a ruling on the paper. You have jurisdiction to do that. So again, there's no reason to rush to get it to any other court. But again, the presumption is that you're going to be ruling on the motion to dismiss and the rest of the case. But I just want to be clear that this sort of rush to have any other court do a motion to dismiss is not the purpose of the venue provision. The venue provision is to make sure that before the case is substantially litigated, there's fact discovery, and there's a trial on the merits, that the fact finder is the proper venue. So the sort of rush is incorrect on the procedural law, and on the merits, the presumption is that this case is going to be here, and we're going to establish that as a matter of law, and there's no basis for a convenience transfer.
Yeah, if I may, Your Honor, if you'll refer to our motion to transfer venue, an argument that a company that merely has access and website within any county in the state of Texas justifies venue has been utterly rejected by the court. So that's just flat wrong.
My cheesecake is my favorite. Mine.
With regard to his argument, they haven't been able to, quote, test the affidavit of no users in Roblox. That was asserted a month ago, Your Honor. They've had plenty of time to test that statement, and it's true. And you would think that the state had venue facts, they would have asserted them. They just haven't met their burden, Your Honor, and they certainly could have met it. They chose not to file the response, laying behind the log until now, and then now waiting, asking for more time from this court and pushing this into the next month or the following will just cause, number one, it's not appropriate because we've already got a hearing set on January 29th. Secondly, it's going to cause a lot of problems for your court. And if you decide that a proper venue or a more convenient venue, which we believe Travis Clowney clearly is going to be really squeezed on that motion to dismiss, Your Honor. So again, we think our motion was well taken. They chose not to file a response. We believe you can take up the motion to transfer.
That it?
Well,
Okay.
I could keep going on the motions, Your Honor, but want to hear from you on what you're thinking and how we can clarify the points. Because again, we haven't had an opportunity. We moved immediately. I just want to be clear. We did not refuse to respond. We moved immediately to extend the deadlines, and that the court has set this hearing, and that motion has not been ruled on.
Okay. Well, we're certainly not going to have a hearing on January 12th, which is mentioned in all the motions, because that was yesterday. I'm not going to take up the motion today. I don't feel particularly moved by getting the motion to dismiss that hasn't even been filed yet to another court. It does concern me that there hasn't been a response filed. I noticed in your motion in plaintiff's opposition, one of the things you asked for was an extension of the deadline till January 16th. Do you think you're able to file a response by January 16th if the court were to grant that part of your request?
We could do that, Your Honor. The only issue, again, is we just haven't had an opportunity to pose their affiant. We haven't had an opportunity to get their documents. So one thing that we could propose here, and if you'll allow me, would be to do, we could file our response by the end of the week. And we think it's clear as a matter of law, to the extent that you think that Roblox's assertion in its affidavit carries the day, which we don't, then we'd want to have a longer runway to take discovery on that. But certainly we could file our response on our burden to show venue by the 16th. I just don't want to forfeit the opportunity and let Roblox's statement about where its users are kind of just stand on its own self-serving declaration when we haven't had a chance to depose the person. So my proposal would be that we could file it but still have the opportunity to take further discovery if it's necessary.
Your Honor, and I would respond to that, that obviously the state, I think, is admitting they had no evidence of any users in King County when they filed this lawsuit and still have no evidence. So I don't know how they established venue without that, Your Honor. How could a cause of action have arisen in that county with no users in that county? To the extent that they need more discovery, we think that's entirely unnecessary. Certainly, if you're going to open up the for more discovery, we probably want the organizational representative of the state that claimed they had venue in this state, and they don't have anything. So, Your Honor, we still believe that if the court is inclined to allow them until the end of this week to file the response, they should do so. That is in effect giving them an additional 18 days to file the response. It appears the judge is interested in doing that. I think that's appropriate, but to open it up for, just to do a improper fishing expedition to seek discovery or venue facts that they should have had when they filed this thing and haven't developed yet, it's totally unnecessary and improper since the response deadline already passed.
Your Honor, one more point there, if you don't mind. We don't think that it is necessary to show users in a county. Now, we still think that we can look into that, given this is Roblox's position. We've got cases talking about advertising throughout the state, an online presence, and we've got the general venue provision. So our point is there are other bases, but you've heard Mr. Burback say that he thinks that the issue of users is the sole issue that goes to venue. And if they're going to make that statement, we ought to have the chance to look into the facts. And that is the point, not that we didn't have a basis for venue. We disagree as a matter of law at his position, but again, to the extent Roblox is going to make this claim, we ought to have a chance to look into it.
All right, so here's what we're going to do. We are going to keep our date of January 29th. I believe it was misstated in one of the motions. It said the 26th, but to clarify, we're set for the 29th at 10 a.m. I will grant the request for an extension of the deadline to respond until the 16th, which is Friday of this week. Now, I do find it interesting that you requested an in-person hearing for this. Obviously, a remote hearing is an option, but if anyone has an objection to a remote hearing, I will grant an in-person hearing, which is what we're currently set for. Do you want to confer and see if you can agree to do this remotely?
Your Honor, I know for us, we always prefer substantive hearings to be in person, so certainly we'd want an in-person hearing.
Okay, that's fine. You can make the trip to beautiful Guthrie, and I will be there as well. We'll be there, and I'll expect that response to be filed by the 16th. Anything else that we need to take up today?
See, that part I don't agree with, but that's fine. Usually when you hear a lawyer say things like, I can prove that really easily, without responding, without citing any cases, without anything, they lost. They've already lost that. The judge is going to rule. You had your chance. You could have. You didn't. We've seen it a million times. So they're going to lose on that one. But it's just, this is going to take years and years and years and years and years and years and years. And no. We are absolutely not going to watch each piece of it as it comes down the pipe. We're just not. We'll all get bored stupid. But it was interesting to see at least a little piece of the lawsuit. You know what I mean? It was just, I don't know. All right. This just happened, I think 2 days ago. I don't know. It just happened. In Florida. This one's for Josh. It's a sanctions hearing. They don't give a response, but their questions tell us exactly how they're going to respond. Here we go. Let me find it. I don't need permission. There we go.
Good morning. We'll be on the record in case number 24-2470. This is NZ Management Group.
And then I got some pictures to show you of people's names.
LLC et al. Versus Sound Fusion LLC and Adrian D. Rivas. Mr. Calzada, could you turn on your camera, please, sir?
Judge, I'm trying to. For some reason, it's not allowing me, which I don't really understand why. I use Zoom all the time and never had this issue come up at all. Can you hear me, Your Honor?
Yes, sir, I can.
All right, here we go. Let's see if this is, I keep hitting start video, it's just not letting me do it. What is going on? The other option I could have is to try a different computer.
We'll stand by.
Okay, I'm gonna close this out and just operate from the an iPad. Okay, just one moment, please. I apologize for this. This is unusual. I'm in on the iPad. If you'll let me in, please. Sorry about that, Judge. I don't know why that happened.
That's okay. We can see you now. All right, so we're here on a order to show cause directed at Attorney Ricardo Calzada individually, why sanctions shouldn't be imposed against him for failing to follow a few of our orders. Sir, I'm going to allow you to respond to the show cause order, but I do want to lay a bit of a background. Before I do that, let me introduce the rest of the panel. I'm joined by the Honorable Jared Smith and the Honorable Rachel Kamoutsas. I'm Dan Traver, and I'm the Chief Judge of this court. By way of background, on November 14th of last year, you filed a notice of appeal in this case of a trial court order involving a final judgment on a promissory note. You filed the notice of appeal on behalf of 4 appellants, NZ Management Group, Inc., Luis Javier Lizardi, Nisha Peña Pantojas, and Oscar Baudilio Figueroa. The judgment was imposed against those 4 defendants and appellants jointly on May 8th I'm sorry, that was November 14th of 24. On May 8th of 25, after we issued some orders directed to you as to trying to figure out why the record in the initial brief hadn't been filed, you filed a suggestion of bankruptcy on behalf of the 3 individual appellants. You identified their pending bankruptcy case numbers in the Middle District of Florida Bankruptcy Division in that filing. 6 days later, we noted the automatic stay and directed the parties to provide a bankruptcy status within 120 days. That 120 days came and went without a status being filed, and on September 17th of last year, we ordered the debtor to file a status report within 10 days. That date came and went. On October 7th, having again received no status, we ordered you individually to file a status report on the bankruptcy proceedings within 10 days, failing which we warned you that you risked sanctions. On December 5th, again, having received no status, we again ordered you to show cause. We ordered you to show cause why sanctions should not be imposed against you individually for ignoring our May, September, and October orders. We directed you to respond to our order to show cause in writing within 5 days. Those 5 days came and went. We received no written response, and on January 5th, we set this matter for hearing. A few questions before I allow you to say whatever it is that you want to say, counsel. How long have you been admitted to practice law in the state of Florida?
Since 2002, Your Honor.
Do you have a disciplinary history?
Not that I don't believe so. I think I got censured one time, maybe 10 years ago, but other than that, nothing.
What was that for?
That was for an advertising matter.
Okay. And do you represent these particular individual appellants in their bankruptcy proceedings?
I did not, Your Honor.
Who does?
James Harper.
What is the status of these bankruptcy proceedings?
They are discharged, Your Honor. I filed earlier this morning a status report indicating that the 3 bankruptcies were discharged, 2 of them on August 6th, and the 3rd one on August 12th of this year, Your Honor.
What efforts, if any, between yesterday and when those bankruptcy matters were discharged, did you make to speak to bankruptcy counsel to apprise yourself of what the status of those bankruptcies were?
I spoke to James Harper yesterday and asked him for copies of the discharges, and he sent them to me yesterday.
Is that the first time? When was the last time before yesterday that you spoke to Attorney Barker?
Harper, and it would have been, I was seeking status from him on the bankruptcies. It would have been before August, sometime in summer. I was asking him where he was in the process, and he advised that he was having an issue with one of the three, but obviously he resolved it.
What steps, if any, other than the status report that you filed this morning, and for what it's worth hasn't hit our docket yet, at least not that I've seen, to move these appeals forward?
None, Your Honor. I was waiting to learn that the bankruptcies were discharged, and honestly, Your Honor, I just missed the orders that were emailed to me that you mentioned. And to be frank, Your Honor, I missed the order for today's hearing as well. I got a call yesterday from your clerk, Stacy, and I called her back immediately, and she thanked me for calling her back, and I said I should be thanking you for calling me because I missed it. I wouldn't have been at this hearing today, Your Honor. Those orders are going to the correct email address, but I closed my practice some time ago. I'm an in-house counsel now to a corporation. And so this is an old relic case from 2017. I closed that practice in like 2018. And this matter came basically one of the last 2 or 3 cases that I had to try to finish out. And so I don't regularly check that email address. And I'm just glad Stacey called because I wouldn't have made this hearing and I would have been in real trouble. I'm not making excuses. I'm just letting the court know how this could have happened. There was no excuse for it whatsoever. And I take full responsibility for it. As I mentioned in the status report, the intention of the bankruptcies was to discharge the debt associated with the judgment. That has now occurred, and the intention of the appellants is to dismiss this appellate action as quickly as possible. I spoke to one of the 3 appellants yesterday. He confirmed he's in agreement to do that. I reached out to a second one, and he has not returned my call yet. But I've spoken to all 3 of them about the intent here on the bankruptcies and the appeal, and the intention from the beginning was that if the bankruptcies went through and were discharged, the appeal would be dismissed as well. I will add one more thing, Your Honor. As this was an old case of mine, I was really diligent at the time when the judgment was entered, and in that 30-day period to inquire from the clients what their intentions were, whether one appeal or not. They told me no, 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 up until the last day when they changed their minds and said, we want to file an appeal. And I was flabbergasted and had this really scurry and file this thing as quickly as I could. They did not pay me for it. They didn't pay my costs that I forwarded for everything that I did. And I told them I was going to have to withdraw. And that's when they decided to file the bankruptcy with Mr. Harper. So, this has been a disaster for me personally, Your Honor, at this point. I'm upside down on every which way possible. And now to receive this order to show cause is humiliating. I've never had an order to show cause against me before. I apologize for wasting the court's time. I've never willfully disobeyed or ignored a court order before, and it sure looks like I did here. I didn't, Your Honor. And the fact that I didn't know the hearing today, and I got that call, I'm just glad she called. So there's no excuse for it, but that is exactly what happened, and I will accept whatever punishment the court gives me.
So I appreciate greatly the candor and the acceptance of the responsibility. I can't speak for the rest of the panel, but it helps me. And I know you're referring to the name that perhaps that you were given, but the person who called you is Stacy Pechtel, who is our clerk of court, who oversees our clerk's office. You've got 3 judges who've convened a sanctions hearing because multiple orders were not responded to that were received. And a decent amount of time and resources has been expended in getting ready for this. So acceptance of responsibility aside, have you given any thought as to what an appropriate sanction in this case might be?
I haven't, Your Honor. That's just, I realized this yesterday, close to 5 o'clock, and I did not think about what appropriate sanction would be, Your Honor. Apologize.
It's okay. Judge Smith, do you have any questions for Attorney Calzada? And I think you're muted, sir.
Yeah, Mr. Calzada, we do appreciate you taking responsibility, certainly. I guess a couple questions that I have. When you got the initial order from our court, I assume, did you get the initial order from our court, the one that stated that we needed a status update within 120 days?
I went back and looked, Your Honor, and I think I received 3 separate orders requiring me to file something within 10 days, 2 of them, and then third one within 5 days. So they hit my account. They hit the email address. There's no doubt about it. Okay, they didn't go to junk. They were in the inbox.
Did you, going back to that May 2025 order, the one where we said, tell us what's going on in the next 120 days, when is the first time you saw that particular email?
Yesterday. When I talked to Stacy, I began doing keyword searches, and that's when my heart sunk.
Okay. And I assume when you initially filed the appeal back in November timeframe 2024, at that point you were watching your emails to ensure that it was properly filed.
For sure. Yeah, for sure. No, I checked it to make sure it got filed. I called the clerk's office. I for sure did all those things to make sure that it was timely filed.
And you mentioned, and I just want some clarification on this. You mentioned that you were shut down your practice in the 2017 to 2018 timeframe. Is that correct?
In 2018, up until 2018, I had a robust practice here in Central Florida. I took an in-house counsel job summer of 18 in Colorado, and basically, I won't say close it down. The LLC is still active, but the practice itself was shut down as I took this in-house counsel job.
Okay. And as of 2024, the end of 2024, how many cases did you have left at that point?
Off memory, less than 3.
Okay.
I sort of feel
cases in an appellate status?
None whatsoever.
if the number is less than 3, you should be able to count that. I just feel like that's a number you should be able to count easily.
And that's kind of what threw me off, that the email section is different for the appellate court than it is for the courts that the other cases were in. And so I just,
the section.
I wasn't picking up that these were coming from a court, and that's my mistake. I think I've only filed one appeal in my career, and that was probably 10, 15 years ago. This is only the second one. I'm not an appellate attorney. And again, I only filed this one because I was given no choice at the last minute by the clients. It was a defensive filing to protect my license.
My email is very organized. I have 11,000 unread emails.
All right. Thank you. I don't have any other questions.
Judge Kamoutzis, do you have any questions?
So just to clarify, you filed the notice of appeal in November 2024 with one email, and is that right?
It's that I used the same email.
From your prior practice?
Correct. It's the same email from the prior practice, and I still have that email open and operational. It's just not something that I regularly check.
Okay. And since 2024, November 2024, did you check that email account?
I have checked that email account on a number of occasions since that time frame. Yes, I have.
Since November, but
Yeah, and in fact, I know that I received emails regarding this case because I had to file additional documents after the appeal was filed. That's when I was cognizant this was happening and was looking to see what I had to do to move the appeal forward. Then the bankruptcies were filed, the automatic stay was issued, and it just went on the back burner. So I wasn't actively looking like I should have.
okay, because you did get and receive the request to provide a status update within 120 days. You did receive that.
I received all of everything that was emailed to me regarding the case is in my inbox, all of them.
But I think
I
think
lied.
just so I
Not
can understand and make sure I
11,000.
understand your answer. For the May 14th, 2025 request for the status update within 120 days, when did you first see that? Was that yesterday or around May?
Yep,
Okay,
yesterday is when I went back and found all of them. I just went back one December and then October, November, then October, and then May, and I'm like,
Okay, I don't have any other questions. Thank you, Judge.
Is there anything else that you want to say, counsel, before we recess?
I think I've said it all, Your Honor. I would never willfully violate or disregard an order. I know it looks like I did that here. I didn't. There's been no prejudice to the clients, which is the most important thing. And I apologize to the court for wasting your time. Whatever you need me to do, I'll be happy to do it. I'll do some pro bono work for people. Whatever you need me to do, financial, I'll do it. I'm in the wrong and I accept responsibility for it.
All right, thank you, counsel. We'll take the matter under advisement and we'll issue an order and we're in recess.
So I know he's in trouble. I just don't know how much trouble he might be. Even when I worked for the university, I had tens of thousands of emails that I never even opened. Nope. Listen, if you need to talk to me, email is not the way to go. Neither is texting or calling me or sending me a message. All right, guys, are you ready? Are you ready? All right, sorry. If you're here for court videos, they're over. Thank you so much for coming out. I appreciate it. All right, guys, are you ready? Are you ready? I gave you guys an assignment, and four of you did do it. Four of you did it. I mean, I only been saying it for months, so I guess maybe I should have given you more time. But here we go. Hold on, I'm gonna get rid of Twitch and me, and then there we go. All right, and we have to guess whose little toe that is. Toe jam time. All you were supposed to do was write your name on a piece of paper with your feet. Let's see how people write with their feet. I am not going to tell you who wrote that because that's cheating. Yep, Josh got it right away. Josh is 1 for 1. Next. That's annoying. Hold on, I can fix this. I have the power. Good luck figuring this one out. I just see beer. Wait, is there a picture in here? I just see beer. You were supposed to write your name with your toes. I just see beer. Linus, you got it. It's Josh. That is a slow transition. That is awesome. Except there's no beer in this picture. What the hell? It's very hard. I had to do it a couple times. No idea who that might be. None whatsoever. It's Saturday. I'm not driving anywhere. I can drink me a river. Yay, Jude, you got it. 2 more. Oh, sugar. Well. I don't know. Dona, maybe? Maybe. I know. It's hard. Martha, it was hard to do. All right, there's one more, guys. One more. Here we go. I'm trying not to sing the song when I look at this, because every time I see that name, I sing it. I didn't miss anybody, right? Right. Bobby, that's beer. Bud Light is beer. It just is. Anna! Yep. The only toe was definitely... Oh man, this takes forever. All right, hold on. We got a toe. We do got a toe. Wildfire. Wildfire is Anna Banana. There's a toe. Yeah. I wonder if that'll stay. If I put it back here. That way, people know my name. Right? We all got Parkinson's. Maybe. You never know. Listen, I just found out today that if I lost both of my arms, I could still write. I didn't draw anything by my name though. Darn it. I just lost an opportunity. Yeah, Martha, I feel if given the opportunity, like I had to, I could get better at it. I feel I could get good. Listen, this is almost better than my handwriting. No feet pics. Oh, no. And seriously though, I'm not 100% sure you can actually sell feet pics. Okay, I know people say that. And maybe there are a small handful of people who buy feet pics. But I feel like there's really not a lot of people that actually purchase feet pics. I just feel like that's more of a hyped up thing than an actual thing. I curse afraid. I mean, it's just such a pain to print. You have to keep picking the pen up. Every freaking letter. Actually, I'm a hybrid. I do a lot of cursive and print sort of together. It's just a hybrid. Type with your toes. Type without your hands or arms. That's what I'll go with. However you want to do it. Just type without your hand or your arms. That toe looks fine. They're all you Roblox users. The people who buy feet pics. I just really don't feel like there's a huge foot market. I just don't. And that's not something I'm going to look up and figure out either. You know, I'm just going to go with what I think and roll with it. All right, guys. I'm going to start OJ now. Today is Saturday, okay? Listen, there's no stream tomorrow morning. Our stream is tomorrow night. It's Sunday night. Because I'm taking one of the streams just to introduce our stream to new people. I can't do that at 4:30 a.m. because everybody's asleep. So so I can't introduce our stream to new people at 4:30 a.m. So to introduce my stream to new people, I have to do it in the evening when people are awake. I wish we would have gotten a bigger Australian crowd, but we did not. It did not happen. So we got to go back to America. And if I stream during the day, during the morning, like now, YouTube sends out most of my notifications. So then if I stream twice and I stream later at night, I don't have any notifications left. YouTube doesn't tell anybody I'm streaming. And here's the deal. When I first start my stream, when I very first start my stream, if an X amount of number of people don't join and watch, doesn't matter how many come afterwards. YouTube's not going to show it to anybody else. That's it. I get a tiny window at the beginning of my stream that if people don't click on that notification, YouTube says, not even her subs are watching, so no, we're not showing anybody else. So if I don't have any notifications left and I start a stream during the evening, nobody clicks on right away at the beginning of the stream. So YouTube refuses to show the stream to anybody else. And that's why no one is coming in. I get very few people in the evening. Compared to today, it's half of that. So I have to not stream that morning so that I have my YouTube notifications. But I try, JK, to give a warning. So what I do is I go live. Well, no, I create the live and I put the notification in Discord. And the live is created, the notification is in Discord. And then I chill for, I let it chill. I let it sit for a few minutes just to give everybody time to, zen. And then I go live. I have to. There's nothing else I can do. I get penalized if I start my stream and there's nobody there. I get hugely penalized. So, are we dating Linus? Don't date my wife. Was it Tuesday? I thought it was yesterday. So was that Monday here? Oh gosh, international hurts my head. Linus, you're gonna have to be more specific when we get closer. Guys, don't forget to join in Discord. There's vocal vibrations. It's down the list where you can talk to other people instead of just typing. So while Linus is going through her chemo, fighting a mountain, we can all talk with her and each other in vocal vibrations. It'll be nice to hear everybody. You can also turn your video on if you want to and see people. You don't have to. I mean, it used to be high pressure, turn your video on. When you got into there, no. You don't let anybody tell you have to turn your camera on. You just don't. But you can. Not only that, you can go there right now if you want to. You guys can talk to each other at any time of the day or night, down in vocal vibrations. There's no rules of when you can and when you can't. It used to run almost 24/7 in Discord. There was always someone in vocal vibrations talking, and then they would break out and play games together a little bit further down. But anyway, I gotta start OJ, or my OJ people will. No, it's not really that late. We're doing good. Thank you for coming out. I appreciate you guys. I do. And I shall see you tomorrow night. All right? Behave, guys. Bye.
happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright, she's got that grace. Come join the fun, it's a welcoming place. I can count on distraction from my pain, 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her style is classy, she's always top shelf. Don't take my word, come and see for yourself. Her cases are new with a twist or two. I really like them, I believe you will too. A little lifeline passed along in rhyme. Why don't you join us? It's a guaranteed good time. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright, she's got that grace. Come join the fun, it's a welcoming place. And so in conclusion, I'll wrap up this song. I hope I didn't miss anything that would be wrong. Hope I see you around. Don't stay on the shelf, join in the laughter. Come and see for yourself.